Hello, hi, good day everyone. Welcome to the virtual launch of Lexis Clause Intelligence. To kick off the event, we will start with a panel discussion on the topic, Drafting Legal Document in the Modern Age, Is Google Enough? My name is Tina Mariappan and I am the Senior Legal Counsel for LexisNexis Southeast Asia, and I'll be your moderator for today's discussion. With us, we have 4 esteemed panelists, Jonathan Tan, Cheryl Cheong, Subhashini Munisamy, and Gladys Ho, who will be sharing their insights and experiences on this topic. A little bit of housekeeping before we start. For those of you who are tuning in, feel free to pop in your questions for our panel member into the Q&A section, and we will pick that up time permitting. Now, let's get to know our panel member a bit more. Maybe we can start with you, Cheryl, if you could just share a bit of your background for our audience.
Sure. Hello, everyone. Thank you for having me. I am Cheryl Cheong, and I am a Senior Transaction Legal Counsel with Partners Group. Partners Group is a private markets investment firm, which is headquartered in Switzerland. So my role in Partners Group mainly is to work on fund investments and M&A transactions. So on a day-to-day basis, we work with a lot of legal agreements. And I would say that technology is a vital part of our business, both from the legal and the non-legal end.
Thanks, Cheryl. How about you, Gladys?
Hi, Ms. Tina. Good afternoon. Good afternoon to all the participants and speakers. My name is Gladys Ho. I'm the in-house lawyer of Regency Specialist Hospital, based in Johor Bahru, Malaysia. Regency Specialist Hospital is part of HMI Group, a regional private healthcare provider based in Singapore, with a presence in Indonesia, Malaysia, and Singapore. So my daily work will be inclusive of providing legal advice to all of the heads of department in hospital, and also to draft on policies and also legal drafting. Thank you.
Thanks, Gladys. Jonathan, you're up next.
Right. Hi, Tina, and hi, everyone.
Hello.
I'm Jonathan, an Associate Director in the Shipping and Commodities Practice Group at Helmsman LLC. Now, Helmsman LLC is a Singapore law firm. We are a relatively young firm. We started in 2019 with 3 lawyers, me included. We've now grown to 17 lawyers in Singapore, 2 in Hong Kong. And shipping and commodities work is our stronghold, but we are also ranked and recognized in other practice areas, for example, dispute resolution and employment. Myself, I'm in the shipping and commodities practice group. So I'm a shipping and commodities lawyer. I mainly do transactions, but from time to time, I do get involved in disputes, litigation, or arbitration. Now, I handle the whole gamut of transactional work for shipping and commodities companies. So that includes structured trade finance documentation, other banking documentation, as well as your normal share sale and purchases. Yeah.
Right. Thanks, Jonathan. Subhashini, last but not the least.
Hi, everyone. My name is Subhashini, and I work at MPI Generali Insurance Berhad. We are a general insurance provider to individual customers as well as corporate. And on a day-to-day basis, we provide legal advice to stakeholders and then business owners and management. And we also look at contract drafting, reviewing, as well as product reviews, including insurance policies, marketing materials, and other notices. And I would say that this would be my 2nd year at MPI Generali. Previously, I was a practicing lawyer in the area of civil and commercial litigation. I would say in-house corporate role is a very new role for me. And shifting from private practice, from drafting pleadings, affidavits, cost papers like submissions and all, to drafting contracts, and the insurance industry itself is very new to me. And I would say with the guidance and support of my team members, line manager, as well as my colleagues, I would say that it was possible, and it is a smooth sailing journey at MPI Generali. I think with the right people, you grow each day. Thank you.
Right. Very well said, Subhashini. I reckon we've got a very varied panel of panelists today. I guess all of you have either litigation background, then you moved in-house, or both, like right now, all of you are doing more transactions So it's good. You will share a variety of inputs with the audience today. Now, just moving on to our first subtopic, legal drafting. Now, legal drafting is not a walk in the park. It definitely takes a lot of time, diligence, and practice to master the art of crafting a watertight agreement for your respective client or stakeholder for their need, and also to ensure that that particular document can stand up in court if challenged. So that is one. And also, often when we are presented with a task of drafting, we would either refer to a past template or speak to a more senior lawyer who've handled similar issue. We'll look at forms and precedent. And of course, at times we do Google, right, for templates or even clause recommendation. So having said that, Jonathan, perhaps we can start with you. How large a role does legal drafting play in your day-to-day work?
Right, it's every day. Now, like I said, being a transactional lawyer, mainly I draft, review, and amend transactional documents every day. I typically, so what it typically encompasses, at least from my perspective, we have trade finance documentation, banking documentation, or even like from time to time where, say, one of my clients wants to invest or buy the shares of another company, that will be a share sale purchase agreement. I typically draft for more complex documents like trade finance, structured trade finance products, that kind of documentation. For a simpler document, sometimes we do delegate to a junior to do a first cut and then review. And so it really depends on the complexity of the documentation or the task, but we always work as a team. Right. And I love drafting. I find it far more enjoyable than litigating. When you're litigating, you're trying to dissect what the spilt milk, essentially, where everything has gone wrong. And then when you dissect into a document, you see every clause that should not be in there is there. So the wording has gone awry, and typically that's why parties fall apart, or they have to litigate on the particular wording of the agreement that's before the court or the arbitrator. But that's why I prefer being there to preempt all these issues. Yeah.
Right. Very well said, Jonathan. That takes me to my follow-up question is, what does it usually encompass? Like, do you usually do the drafting or do you mostly delegate? But I think you've already answered the question.
Yeah, correct.
For the simpler ones, you do delegate to your junior lawyers. And of course, I'm sure you would monitor their work as and when it comes.
Yes, that is right. Typically, I draft a bit, well, I guess I would say a bit more challenging documents, especially where documents which need a bit more experience. So maybe a simpler document like maybe an employment contract or parent company guarantee. Those are a bit more, I would say, block standard,
right?
Where we have precedents, or even Lexis as precedents. Then it's easier to cross-refer and understand, and for them to start to draft. So we all start somewhere, and I think over time, with more experience, as they get involved in the deals, they build up the experience and they can move on to more complex documents.
Right. Yeah, that's right. How about you, Gladys? Like, how large a role does drafting play in your day-to-day work?
Okay, for being an in-house lawyer in hospital setting, I would say for drafting work, it will be carry about like 60% of my workload. So, and actually, I do agree with Jonathan. It's better for us to kind of preempt rather than being into litigation. Because before joining Regency Specialist Hospital as in-house lawyer, I was a litigator lawyer in court. So I mean, after practicing for quite a number of years, I found that okay, maybe it's time to see the other side of the moon. That's why I joined in-house. And for being the legal advisor in hospital setting, right? I think it's very useful for me to use my experience when I was a litigator to kind of do some prevention and to draft a better contract, and also to refer to Lexis forms and precedents for me to draft a contract to ensure that the hospital interest is well protected, so that can definitely avoid the risk of being sued in court. So I would say the drafting percentage will be about 60% of my workload.
Right. Gladys, I'm also curious to know, how big is your in-house legal team? Do you delegate work up to a more junior member within your team?
Okay, so actually in Regency Specialist Hospital, I'm the only legal advisor. Right. So I'm the only person in the legal team. So it depends because actually Regency Specialist Hospital is under HMI Group, and we do
Right.
have like sister hospital Mahkota Medical Center in Malacca. So
Right.
normally if we have any project, like for example, like maybe anti-corruption project kind of thing, so we will engage external lawyer so that we will do the project together and draft the policy together so that it will be
Right.
applicable in group. But for other kind of agreement, like I would say like master services agreement or some agreement like employment letter and all, we will just I will just draft it by myself internally.
Right. Okay. Thanks, Gladys. How about you, Cheryl?
So given that I'm in-house,
Yes.
like Gladys, actually, we have a very lean legal team. Globally, we have about 6-7 transaction counsels. And given that we work on a high volume of transactions on a day-to-day basis, we actually don't do the legal drafting in-house.
Yeah.
For us, we actually have our external lawyers draft it. So
Right.
like
Okay.
Jonathan, for example, yeah, they do actually hold the pen and do, they attend to the details of our legal agreements. So my role instead is actually more of a review and advisory role. With that said, given that, we're still lawyers in-house, I review the legal drafting of my lawyers on a day-to-day basis. Yeah.
Right. I reckon you'd also probably review agreements that you get from, say, your vendors or, your external client of your organization.
That's exactly right. I mean, so we have agreements that are generated by counterparties,
Yes.
counsels from the other side. We also do have templates in-house, which I have to look at and amend it, here and there. But with that said, that's a very small percentage of my work.
Right.
Yeah, but within Partners Group, actually, we do have other legal teams that do more legal drafting on a day-to-day
Right.
basis. I do.
Yes. Okay. All right. Got you. Subhashini, how about you?
Since we are in the in-house setting, we mostly do contract reviews, product reviews. Drafting, I would say it will be relevant when we are giving advisory opinions. And then if, let's say, there's any internal process that you need to straighten out, or creating SOPs or policies for the companies, then legal drafting would become very relevant. I would say drafting is a fair portion, or in as much as we review contracts and other documents. So drafting takes 50% to 60% of the percentage.
Right. So do you delegate your work? Like, how big is your legal team?
We are just 2 of us.
Right. Okay.
We used to be a very big team, as in like legal and compliance combined department. But right now we are just a small team, and most of our engagements and transactions revolve around commercial agreements, to which we have like contract templates pretty much that we can just populate the terms of engagement, the service level agreements, and all that. So the only thing that we delegate is when we require like specialized expertise of an external lawyer, or if, let's say, there's an unusual matter that is beyond our expertise, or if you want to litigate the matter, then of course we resort to the assistance of external counsels. So that's where delegation comes in. Otherwise, drafting and reviewing are done by us.
Right. Thank you. I'm just curious to know, like, when we are presented with a new task, entirely new project, how does our panel members deal with it? Like, it's a new request and you need to draft a contract. How do you go about creating an agreement, say? Cheryl, maybe you can like just share your input on this.
Sure. So it depends on the agreement, actually. If we do already have templates, we start from our templates. There is no need to waste time to draft a document from scratch. If it's a very bespoke agreement, we tend to work very closely with our external lawyers to prepare it, because then we can glean off their knowledge as well on the market standards for such an agreement and what typically goes into such agreement. If it's actually a client document, and while I don't do this, I have colleagues from a separate legal team that does actually prepare legal documents for our clients who invest with us on a day-to-day basis. If they have such a request, they do pull out from their database of past precedents and then start drafting, modifying from there.
Oh, right. Got you. How about you, Jonathan?
Well, exactly what Cheryl said. If it's a simple or standard agreement, we always look for precedents. Well, we want to just be quick and get over and done with it. But if it becomes a bespoke or maybe something that requires a bit more thinking, even though it may be a traditional agreement, but they just want traditional type of commercial agreement. But parties sometimes, or even clients, have creative or innovative ways of structuring the transaction, or even how they structure the compensation or payment, then of course we need to put a bit more thought into that. But apart from that, typically we start with precedents, yeah, because no point trying to reinvent the wheel when actually you have something there. Yeah, exactly. Yeah.
Right. How about you, Subhashini?
Right. If let's say it is a new area or new niche of contract, we would normally look at the BNM, Bank Negara, who's the Central Bank of Malaysia, the regulator of insurance industry. So we will look at their requirements to see whether if there's any term that is mandatory to be incorporated, then from there we will work on how to draft the contract. And let's say, if let's say those nature or type of document or agreement is something that you have not dealt with before, or you do not have a precedent, or normally, personally, I'll just go and Google up or try some solutions just to get an idea as to how to, kickstart your agreement. Yeah.
Right. Gladian, how about you?
Okay, I have to agree with all. Definitely we'll start with the template.
Yeah.
To save time to work really efficiently. So for those novel type of agreement that is not so common, so normally in hospital we will start with we will ask ourselves, do we have to satisfy the special requirements of MSQH? MSQH stands for Malaysian Society for Quality in Health, because for hospital in Malaysia, it's very important for us to comply with that standard.
Sure.
So apart from that, we will also identify whether there is any latest legislation. And also we do consider about the latest guidance or directory given by Ministry of Health. This is quite unique for hospital setting. So after we have checked through all that, then we will check definitely Lexis Advance to check whether there's any updated legislation and all. Then after that, we will organize our thought. And then if necessary, we'll seek help from external counsel. If not, then we will start to do it by ourselves.
Right. So the theme across the panel, what I'm hearing is we'll go to past precedent, and at times we do Google. I reckon you'll also probably consult with more senior members of your team to see, if they have done something bespoke, or if they've worked on something, similar to what you are working on, or even your juniors are working on. Now, on the same topic, what are the usual challenges you have seen or observed when it comes to drafting? It could be something that you have encountered, or it could be something that your junior members of your firm has encountered. Glady, why don't you go first?
Okay, so I would say the challenge in legal drafting, right, is I would say the first thing is to make sure that you have comprehensive legal clauses to cover that particular transaction. Like for example, in hospital, right, there might be some, in Malaysia, we have travel healthcare council and all. They might want to do photo shooting in our hospital for some advertisement and all. So it's very important for us as in-house lawyer to think of that. Okay, so there's a photo shoot session at our hospital. What shall we do to protect our all the intellectual property interests? For example, maybe we should have a intellectual property license agreement to ensure that we do restrict the right of the licensee in using our photo and all. So I think the most challenging part is to ensure that you have the comprehensive coverage of legal clauses.
Right. Okay. Thanks, Glady. How about you, Jonathan?
Well, the first challenge that I see is about spotting the issues that you see in the documentation that has been, for example, presented to you typically, or sometimes you have to draft again. Then it's about knowing which are the key points to bear in mind when drafting. Sometimes they differ from transaction to transaction. And this is very difficult, especially when you're tired after a long day's work. Your eyes are all glazed over, and then you have to start looking at a document that runs to 40 to 50 pages. Then you begin to wonder, have I missed out something? You begin to ponder.
True.
Yeah. So I think that is really the first challenge, really spotting the issues. And linked to that is really about tailoring the draft, whether it's you're reviewing or drafting it afresh, to the commercial structure of the transaction. Well, a habit that I've seen, at least amongst the more junior, is that they would always say this is a precedent, and then they would be a bit afraid to amend the precedent because they were like, oh, this is what I have seen in the past, so I must follow. But actually, if you look at the commercial structure, sometimes the structure may be a bit different, and like I said, sometimes the way they structure payment, the way they structure how certain things are done is a bit different, so we always have to bear that in mind. So tailoring the draft to the commercial structure of the transaction. And lastly, I guess we have to make sure that any document that we do is market standard, as what Cheryl mentioned, because at the end of the day, there are risks, there are obligations, there are rights, but we want to make sure everything is fairly balanced, in line with market. We don't want to introduce a document that is too favorable to us and then make us look bad, in fact, I guess, as lawyers, and more importantly, even the client, because then they'll look like as if they're oppressive and basically nobody want to deal with them. Yeah, so I think that's quite important. And linked to that, I guess Lexis has quite a good database when it comes to very I would say standard transaction documents, and it's interesting, and I don't think there's out there in the market there's anyone else who has what I would call the Southeast Asian advantage, where basically you focus on Singapore and to a certain and Malaysia, and to a certain extent, as I understand it, Hong Kong. But I don't think there's another database, at least out there in the market, as I understand it, which focuses on Singapore and Malaysia, and Hong Kong, well combined, being all these quite important financial centers. Yeah.
Right. All right. Thanks, Jonathan. I see, like, especially with junior lawyers, when they're presented with a precedent, it's always hard for them to change that up, because they would have thought like, okay, this was worked on by my most senior member. What changes am I going to make? Would that, create confusion or issues later? But yeah, I get where you're coming from. How about you, Cheryl?
So challenges with legal drafting, I'll say that there are many. Gladys and Jonathan, I agree with them. I think what Jonathan was describing was, a lot of it is a lot of manual work, right? Just going through that 40, 50, sometimes hundreds of pages of legal agreement, and that takes a long time. So also because it's so manual, I think that the risk of human error is high also. You have clauses, I think also from an in-house role, being the second pair of eyes that looks at the agreement that has been drafted and not the one being drafted. You can then, you spot the mistakes quite easily. You see how clause references don't tie up, how certain clauses are irrelevant, like Jonathan said, sometimes it's plucked from a precedent that may not be so applicable. Then you have also irrelevant boilerplate clauses. There's just far too many of them. It just makes an agreement too lengthy. The other challenges I see is that I think these days a lot of our agreements have too much legal jargon. The use of double negatives, and being in-house, I can see how it trips up the business teams. They read it and they simply don't understand what they're reading, and just lose patience reading it, right? And so they just go back to you and say, explain to me. I have no idea what it's saying. Tell me what my risks are, right? And also, as Gladys said, we need it to be comprehensive. And what I see also sometimes is that clauses can be very half-baked, or they're not stress tested through different scenarios. They're not thought through like how a situation could practically evolve. And so sometimes, when it's drafted, you look at it and you think, this is just in theory, but in truth, it will never happen. So we need to redraft it such that it's more applicable to the circumstances, or, the risk of these, or rather the future risks that may occur. Yeah.
Right, right. I agree with you, Cheryl, especially on the usage of legalese or very high level legal words in an agreement, which may put off the business or even our potential client. Because the simpler the agreement is, as long as the rights and risk of the of an entity is protected, I think that should work moving forward. But yeah, I think a lot of firms and even lawyers are moving to that direction. How about you, Subhashini? What are the challenges that you see when it comes to legal drafting?
There are many challenges, but one challenge or one thing that haunts me almost every day in my day-to-day work is negotiation with the parties.
Okay.
To strike the middle ground. It is so hard to get parties to agree to a term and come to consensus. This is because most of them or each party does not understand the protocols of the other company or client, and where because every company would have their own terms and conditions, which are used as parameters to how they trade and how they conduct or run their businesses. So if you don't understand this very important or salient things in negotiating any contracts, especially, then you will end up fighting, and there will be like discussion meetings and back and forth. Things like terms like what is the risk that the company is facing, or how vulnerable is a company to cyber threats, and all this kind of terms. I think each party should know what the other party is facing. So in order for us to negotiate and come to terms and reach a consensus.
Yeah. I kind of resonate with what you've just said, Subhashini, especially when we're negotiating with another party or even a client. We as a company, we have our baseline policies, which is an absolute no. We cannot move away from that. But trying to make the other side understand, hey, why we cannot agree to this, sometimes can be an onerous task, and there will be a lot of back and forth trying to explain between lawyers. And I think at times stakeholders or business people will be stuck in between, and they'll be like thinking, why is it taking so long for legal to just say yes or no to something? But we are then guided by all this internal policy and the company's risk that we must always ensure that it's paramount. We have to take care of that. Now, there's one thing that Cheryl said earlier. I wanted to just pick on that word. It's very manual, especially when you are going through tons of precedents that probably your organization would have saved in some SharePoint or even desktop or whatnot. That could be an onerous task, right? You're manually comparing two documents, the new documents that you're working on, and an older document that you have in precedent. So that's pretty interesting, and I think that could be a challenge, and it is also time consuming for, say, junior lawyers or even senior lawyers. When you want something done quick and fast. Now, within your organization or law firm, how do you ensure that your precedent templates or whatnot are always kept up to date? Do you do it as and when needed, or do you make this conscious effort to make sure that the templates are always up to date before it is, say, used by another member of your team? Jonathan, do you want to start first?
So we typically start with our own. Okay, so over time we built our own database of precedents. How do we update that? Typically, we will look at the most recent transactions. I mean, because that would typically reflect the latest market trends, or at least market standards. So and also the terms that are used may change over time. So those usually we look at the recent transactions, but at the same time, we cross-refer against precedent databases, whether Lexis or there are a few others. And I think what is helpful is that, at least from the precedent databases, they do explain sometimes what has changed and whether a certain precedent is under review or maintained. So, and when they update that, then you can see that there are some subtle differences from the previous version that was uploaded. So then I think that helps us to update our own at the same time, because I think frankly it's quite difficult to, as a lawyer practicing at the same time, to also update all your precedents on the day-to-day or if not monthly basis, because I don't think we have the time,
Yes.
unless you have a specialized, what we call a knowledge resource management officer to do it lah. There are, but typically these are the very big law firms lah. Yeah.
Right, right. How about you, Subhashini?
We update our contracts based on rules and regulations of Bank Negara, the regulator. So if there's any new policies come in, then we will see whether our current template or existing contracts does affect or not by virtue of those policies. So that's how we keep up an up-to-date contract just to ensure that we stay relevant with the regulations.
Right, right. Gladys, how about you?
Okay, actually I do agree with Jonathan and Subhashini, especially when Jonathan mentioned that normally we only update the agreement according to the latest transaction, because it's actually no point for us to just check the agreement every day to ensure that we are up to date today. It just doesn't really make sense and time effective.
Right.
So normally based on the latest transaction, like actually we do have some for hospital, we do have some agreements with like insurance company. So like for the patients, when the patient come over to hospital, so what kind of service that hospital is going to provide to that customer of the insurance company. And from time to time, there might be some change of procedure during the transaction, so that we have to incorporate their latest procedure into the agreement to ensure that the agreement is up to date. And that is from operational perspective.
Right.
But however, it's very important for us to look at legal perspective, in the sense that whether there is any latest legislation, and we normally get the update from like Lexis and also like Google and news, we know that, there's a new law. For example, previously there is implementation of Section 17A of Companies Act regarding the anti-corruption law. So that then that was the time that triggered us to update our agreement to ensure that we include that anti-corruption clauses in our agreement, so that in future, if there's any local authority that might want to challenge us, at least we do the very first step in protecting our hospital interests.
Right. So I'm hearing this theme between Subhashini and Gladys, as and when there's changes in legislation or the law, then, both of you will go and, make the relevant changes to your templates of precedent. How about you, Cheryl?
For us, there are two specific things that we do actually. So during the year, we do have regular reviews of our documents, and these regular reviews are done by the legal teams across the globe. So we have a legal team seated in Asia Pacific, in the Europe and America. So the three legal teams, transaction legal teams, will sit together and discuss what issues we've seen in our transactions, and then discuss if our documents need to be updated. And often what we see is that trends, often, not always, they start from the Americas, and then we see them, coming down and flowing on to Europe and to Asia. So that then allows us to quickly, amend or update our precedents. So that's one that we do. We would then, take notes of these and then reach out to external counsels, and together, hand in hand, work to update it. And then while we do that, we also then, discuss with external counsels as to what they see on their recent transactions. So we work with specific lawyers in their different expert fields. If it's a fund investment, we work with fund lawyers. If it's an M&A transaction, we work with M&A lawyers. We ask them, what have you seen in your transactions? We compare notes, and then from there we decide what then needs to be changed in our precedents and documents.
Right. Like for us, as and when there's changes in the laws, say PDPA or SDN, sanction clauses or anything like that, we go about and change, the clauses in our template agreement. And at times, we also look at the usual requests that we get from our stakeholders in terms of some of the commercial clauses. Then we will deliberate internally whether tweaking is needed to certain clauses. If we keep getting all this change requests, is any tweaking needed? Or there could also be instances where there's internal change in policy within the company, then that is another avenue for us to go and relook into our template documents. Now, moving on to our next subtopic, and I'm kind of keen on this topic actually, your experiences on legal tech. With time, I believe legal tech adoption has increased. And when lawyers adopt the right solution, the result can be transformative, both for the business and the individual. And also, legal tech empowers lawyer, right? It will lead us to work more efficiently, and also will be more proactive in our role. Ultimately, we'll be happier doing what we are doing, because to me, happy lawyer equals to higher quality output, right? But I want to ask the panel, if you could share how your firm or legal department has pivoted its strategy to adopt technology to better serve your client or stakeholders' need. Gladys, maybe you can start off first.
Okay, I have to admit that technology is very important, especially for in-house lawyer. Because when I first joined, I found that the work might be rather manual.
Yeah.
So, and it's quite fortunate that a few months after I joined, then our hospital adopt a legal technology, which called like EPR system, whereby we will like the user department will be uploading agreement. So they will get template first, and then they will be uploading the agreement to the system. Then after that, commercial team, they will be reviewing the agreement in the system. So if they think that all the payment terms make sense, all good, then they will update in the system. So I will just get the agreement from the system itself after being approved by commercial team. So that then me as legal person, then we can review the agreement from legal perspective, then we can close the contract. So at least with that technology, we have like kind of like a systematic process. Where like not all the agreements will just like rush to your doorstep at one go. So it will be being resolved by each relevant stakeholders. So after that, only go to your part. So I think that's quite efficient.
Right. Okay. How about you, Subhashini? How about your firm?
Okay, in our organization, we dealt with voluminous contracts coming in every day. So what we have done is we have automated some of these very straightforward contracts like NDAs into the intranet, and some service agreements where our business owners can just use and populate the important details, terms of engagement, and so that we can just pick it up and then review and just automate the approval by way of email. So we don't need to call them 10 times or have a discussion or a meeting. This saves times in a way for more straightforward and simple contracts. So we did automate in terms of contracts that are very straightforward by way of intranet. Yes.
Okay. How about you, Jonathan?
I must confess, I think we're lagging behind the in-house people, Gladys and Subhashini, because okay, as an organization, for in-house, if you're big enough, you have a volume of transactions, right? A significant volume of contracts, agreements, everything, and every day something signed. Then it makes sense to automate things like what Gladys said is on a internal platform, or maybe in the intranet. Within the company. Now, at least for lawyers, I mean, basic things like storing documents on the cloud, having your file management system platform integrate with your financial platform. All this are pretty basic, but I think the next step really for lawyers, which I think is still at the nascent phase, the early beginning phase, is to really have a clause, what I will call a contract clause playbook, where you can. Where basically, I mean, this is going to lead on to Lexis Clause Intelligence, but where you where you upload the document, and voila, you see alternative clauses proposed, especially when we are negotiating. I mean, what Subhashini has described, like populating the data inside the agreement, all this. Basically, if it's this kind of situation, lawyers won't be involved, at least not external lawyers. So when we are involved, it's typically to draft something that's typically bespoke. We need to restructure something different. So the legal tech, when it comes to that, really has to be it's geared differently. It's not automation, like what they're trying to do. Yeah.
Right. How about you, Cheryl? How about your organization?
So my organization actually has quite a large technology team. So I'd say that, in the private markets industry, we're quite at the forefront of using technology to make a lot of our processes and workflow more efficient. So So I think on the legal end, we also have adopted quite a number of tech to help with different aspects of our transactional work. One such technology that we use, we build it in-house. It basically tracks the obligations that we need to fulfill during the holding period of our investments. So as and when, we put in a timer so that we triggered as and when these obligations need to be fulfilled. And then these notifications are then sent out to the relevant teams, whether it's legal or the business team. We also have built or rather developed a tool that allows the filing of all our agreements, because we work with a high volume of transactional documents. And so we've had to build a tool to make sure that all these documents are filed systematically and on a timely manner. And that was required because we actually have duties and obligations to external parties like custodians and depositories and auditors to send these transactional documents to within a required time frame. And so this tool, aside from being able to file, we can immediately go in there and also share the relevant documents with these external parties. And then on the back end of these tools, what has helped us is that we can extract like an audit trail to know when documents have been shared, when they have been filed, who they have been shared and filed with. So actually these, previously, before we had all these technology, it was very manual. We did it all by email. We would attach a large, or many files of documents in an email and send out. And, oftentimes documents we missed or because of how big the email is, it doesn't get sent, it gets bounced back and everyone gets frustrated. So that's how tech has helped us. And within our firm now, actually, we are also putting in place a contract lifecycle management tool. So it would consist of a database and library of clauses that all the legal teams need. So it'd be easy for them to pull out the clauses to put together agreements that we all need. It also has inbuilt workflows to ensure, drafts are reviewed and approved automatically as well. And then it ends up finally where there is an integrated like e-signature tool in it. So I think I agree with you, Tina, definitely all these technology definitely makes work for us lawyers a lot more efficient. And this also then allows us to spend more time on more complicated and high-risk matters for the company.
Right. So what I'm hearing is like legal tech obviously differs between in-house setting and legal firm, but ultimately the bottom line is it helps lawyers to be more productive and be more efficient in our work. Now, tools and technology can help boost productivity in a firm or legal department, but what are some of the challenges that you have observed in adopting legal tech for your legal firm or in-house setting? Maybe we can start with you, Cheryl.
Oh, sure. So for us, of course, there are challenges when you put in a new technology in place. Often it replaces an existing process or workflow or tool, right? So just, the first one that I think of immediately is just syncing that tool with every other system that we have in the company. That takes a long time. That takes a lot of teams to be cooperative, to work together and to also agree that this system would benefit them as much as they benefit us. The other challenge is then also to train people, because not all employees are willing or comfortable with change. So getting them familiar, trying to explain to them that this will make their work much easier, and more efficient takes time as well. And of course, implementing tech in an existing organization always has teething issues. So it needs time to work through those teething issues. Yeah.
Right. Technology and tools are only as good as the people who are using it, right? How about you, Jonathan? Like, what are the challenges that you have observed when tools and technologies are adopted in a legal firm?
Well, I'll touch the most thorny issue, costs. So actually, from a user perspective, and also whether organization or law firm, really at the end of the day, we have to justify to ourselves that this will, bearing in mind the costs and weighing the benefit they will bring, is justified. But typically, when the tech is usually at its early stages, the cost is very high. The cost of adoption is very high, and at the same time, the benefits is not really there. So we have to weigh that very carefully, especially if you're a smaller firm, or as opposed to a very large firm who maybe can spread the costs a bit better across a larger organization or larger number of head of lawyers. Then the other two issues, which Cheryl touched on, being familiar with the tech, getting up to speed, and trying to integrate it with existing systems, they're all very relevant and actually quite important, because very often you don't want to just adopt tech and then some legal tech, and then at the same time, it doesn't integrate or sync with your system. It just creates more frustration, more delay. Yeah, it just doesn't help things. Yeah.
Right. How about you, Subhashini? What are the challenges that you have seen?
I would say that we are no different in our organization. We are no different than small firms or small settings, because in some in-house legal team or department is perceived as cost-centric department, as in where there's limited budget allocated to run or manage the department. So some organizations, they're very receptive to have a legal tech in their department, but some think it is a low priority for the business. And some even have the mindset or ideology that when I can have the manpowers or the resources, the current resources to manage whatever workload that we have, then why do we need a legal tech?
Right, agree. How about you, Gladys?
Okay, I do agree with Shara and Jonathan. Like basically in a company, for people to believe in technology itself, it spends much effort. Like you really have to get the people to trust that, okay, if you are going to adopt this technology, it's going to be very helpful in your work. Just doing this part, it requires you to like maybe give training to them, and also to really sit down and listen to them, like about what are the current issues and how will this technology will be helpful for them. So it's to get the people to understand and be comfortable with it. I would say this is the most challenging part. And secondly, if we can get through that part, then secondly, it's also very important for us for the people to maximize the usage of that technology. For example, even though we have the contract management system, people might just like prefer maybe the rather traditional method in sending document to you manually. But it's very important for them to understand the exact usage of that system. So that after understanding it, definitely everyone will be able to increase their efficiency in the work.
Right. So what I'm hearing from the panel members is the challenges are, firstly, it's cost, of course, getting the buy-in from your management to say why we need this technology. And of course, the mindset of people, once you have the tech in, people need to change their perception and, start using it. And some, I think, like Subhashini mentioned, just wait and see. I've already got the people resources. Why do I need this tech in my organization? So I guess when a technology is user-friendly, cost-effective, purpose-built for a particular organization, and when a firm or legal in-house department or legal firm can see the return on investment, if I purchase this product, this is what I'm going to see in a short term. That would appeal to a larger audience, I suppose. With that, I'm coming to my final question, and this is specifically for Jonathan and Subhashini. I believe both of you have either trialed or have seen demo of our latest solution, Lexis Clause Intelligence. So I just want to know, what are your thoughts on this product? Maybe we can start with Jonathan.
Yep. Okay. So I think it's quite a good contract clause playbook for standard transactional documents. I mean, to be honest, it's very easy to use. You just drag and drop the document that you have in, which is probably in Word format, and then they'll just cross-refer against what they have in the existing Lexis database. What I particularly like is that they flag out all the alternative clauses and tell me what are the precedents, whether it's pro-buyer, pro-seller in, for example, a sale and purchase scenario. And then they also flag out to me, more importantly, the sub-clause, and the ease of use is quite critical. They allow me to plug and play the sub-clause that I want, because I may not want to change the entire clause.
Right.
So that's quite important, and I think to me it's also quite an easy way. Well, I mean, one way of finding out whether the document is fairly market standard, at least when it comes to this kind of standard transactional documents. Yeah. So I think it's very useful as a drafting aid. It certainly doesn't replace the lawyer, because the lawyer still has to make the value judgment of whether this clause is good or the other clause is good, which unfortunately the AI can't do it as yet, not yet, but who knows, we'll see. Yeah.
Right. I guess that's mindset of some of the lawyers, right? If I adopt this technology, is it going to replace lawyers moving forward? But no, it's not always the case. We always need lawyers. AI is only as good as it is, but we always need the brain behind it to see how it operates. How about you, Subhashini? You would have seen demo of LCI. What are your thoughts?
Okay, my experience is no different than Jonathan's. And I would say that I'll have to admit that I'm not a tech-savvy person, but with the LCI, the legal Lexis Clause Intelligence, the functions or the tools or the features are so easy to navigate, and you can just have to click on those, hamburger or even the icon, and everything just pops out. You don't need to, open a separate tab or open a separate link or even any downloading of any application. And second of all, I also like the part where if let's say you are drafting a fresh contract, or even let's say you want to draft a clause like indemnification or limited liability that suits your client or your parties, then you can always draft in those terms and upload them into this platform, and it will give you all the recommended clauses. So it's kind of give you an idea on how to expand and improvise those terms, right? Okay, so and then I also like the part where Lexis Clause Intelligence was suggesting me all the relevant laws that you can that is can be applicable for the contract or even the clause that you're working on. For example, there will be a clause saying that if let's say there's any litigation matter, then parties will need to, litigate or bring a cause of action within a time limit under the law. So instead of putting it very generic, Lexis Clause Intelligence is suggesting that maybe you can consider Limitation Act, something like that. So that is the last point that I saw in Lexis Clause Intelligence. So it was a good experience that I had.
Thanks, Subhashini. What I'm hearing is a big tick for user friendliness of the solution. So that's good. Cheryl and Glady, we look forward to sharing with you how our LCI works, and stay tuned. We're going to launch it in due course. So with that, we come to the end of our session. I'd like to thank our panel members for joining us today and sharing your insights. I'm sure the audience members would have enjoyed the session as much as I did.